the Mountain View Senior Center and those joining us online. The humanist community is a chapter of the American Humanist Association. Humanism is a secular and reality-based philosophy of life that affirms our ability and responsibility to lead ethical lives of personal fulfillment that aspire to the greater good. We value freedom, health, happiness, fairness, compassion, and using science and reason to acquire and apply knowledge. If these words describe your thinking, we invite you to become a member of the humanist community if you have not yet done so. Membership forms are available on our website. A special welcome to those who are with us for the first time. We invite you to continue listening to our weekly forums and other events. You can find all our events listed on the website. Please aid us in continuing to present these forums by donating to the humanist community. You can find out how to donate to our organization on our website, www.humanists.org.
So our speaker today is Zem Laski. In 1973, the Supreme Court ruled on Roe versus Wade that abortion was a right of all women in America. And in 2022, in Dobbs versus Jackson, they overthrew that right. So the question is, what's the philosophy of the Supreme Court of the United States? Today, Zem will discuss these philosophies and their effect. Zem has a bachelor's in international relations from Stanford and a master's in information and computer science from UC Irvine. And he has a great interest in what's going on in the world. So, Zem?
All right. Okay, hi, I'm Zem Laski, as Alex introduced me. And I was always interested in both these cases, Roe v. Wade versus Dobbs and Jackson, because they came up with sort of opposing conclusions, right? And so how is it possible that a Supreme Court of a single country will actually come up with this, this sort of a divergence? So that's sort of what I want to talk about today. So the background is that, abortion is a difficult issue. It's, on the one hand, you have the woman's right to choose and bodily autonomy, which is a serious and valid proposition. On the other hand, you have sanctity of human life, which is also a valid argument to make, regardless of which side you're on this issue, right? Unfortunately, the legislature, the Congress in this country has been completely dysfunctional and has not addressed this issue. For instance, Roe has never been codified. They had 50 years to codify Roe in Congress, never did it. In 2022, they tried this last ditch effort called the Women's Health Protection Act, and that went nowhere, I guess because we had, too many Republicans in Congress. And then the other interesting example for me is the Equal Rights Amendment, which was submitted to the states for ratification in 1972. The state of Virginia ratified it in the year 2020. It became the 38th state to do so. And so the Equal Rights Amendment will now be law, except when they did it, they set a self-imposed deadline on it. They said, well, first it's 1979, and then they said, well, okay, 1982, and then nothing. So it's kind of weird. And the reason it's weird is because if you look at the 27th Amendment, which deals with, that's our newest one, by the way, deals with salaries of Congress people. It was ratified in 1992. It was submitted to the states in the year 1789. So the wheels of justice turn slowly, but I didn't think it was this slowly. So anyway, all of this falls on the judiciary then, right? Judiciary has to decide, delineate policy for states. It has to, decide the rights and responsibilities of individuals. The problem is, courts are not really designed with, policy determinations, but policy design. They're designed with interpreting the law, which is really something different, right? So we really have a mismatch between what we need to do and what is actually happening. So anyway, I just thought I'd give a really quick overview of the two cases. So first we have Jane Roe, aka Norma McCorvey. Actually, I should say Norma McCorvey, aka Jane Roe, versus Henry Wade. Henry Wade almost prosecuted Lee Harvey Oswald. That didn't work out though, so he prosecuted Jack Ruby instead, sentenced to death. So anyway, Jane Roe was actually recruited by pro-choice activists. So this was somewhat synthetic. She was white, she was poor, she was pretty, and she was pregnant. That was the criteria that they used. So first, she wanted an abortion in Texas, which of course was not legal. So she went to the U.S. District Court for the Northern District of Texas. And which is interesting. That's when actually it became a class action. She basically rewarded the thing to say Jane Roe and persons similarly situated, right? Which is like a class action suit. They also had something called a plaintiff intervener. I've never heard of this before. This was a doctor representing the medical community in Texas, because one of the problems with the Texas statute was that it was vague. And so doctors were not sure when liability would arise. So they had an interest in actually figuring out what the hell is going on with this thing, right? Jane Roe prevailed on 9 amendment grounds. The Ninth Amendment says that the enumeration of certain rights shall not be construed to deny or disparage others retained by the people. So this is known as unenumerated rights. That's sort of the concept, right? And then the court also, so I maybe went out on a limb a little bit, said that, fundamental right of choice over events which bear in a fundamental manner in the privacy of individuals. In other words, the right to privacy, which was kind of a novel idea, that the court introduced. So this was appealed to the Supreme Court. Actually, it's not clear to me if they actually went through the Fifth Circuit. They should have, because they started in the district court. So before they reached the SCOTUS, they should have gone to the Fifth District Court. But I never found that on the web specifically. So I'm assuming they did. I don't know if they did. So this is actually where it gets a little murky. It was very politicized. If you read about how the justices deliberated, they had things like, well, who should write the opinion? Should Thurgood Marshall write the opinion? Well, no, he'll piss off the African Americans. Should this guy write the opinion? And I find it weird because these guys are unelected. They're there for life. Why do they give a thinker's damn about what the African Americans think, or the Italians think, or the Catholic Church thinks, right? Nevertheless, that's what they did, which is weird. So initially, the initial draft focused on the vagueness, which kind of goes back to the intervener part, right? That the thing was vague and so had to be struck down. But then I forget which justice started this, but the more liberal wing said, no. It really has to do about privacy and the right to privacy. That's where the statute is mistaken. And so that's sort of what they went. The case was re-argued because 2 justices retired and 2 new ones came in. One of the 2 that came in was Rehnquist, who was, of course, a conservative. And I think the other one was Powell. And so then they ruled 7-2 in favor of Jane Roe and introduced the constitutional right to privacy, now since the Supreme Court, relied on the 14th Amendment, which is, I'll get to that in the next slide, although they accepted the 9th Amendment reasoning of the district court. I thought they thought also that was another way of getting at it. They rejected the personhood of fetuses, which is interesting. They did say, well, are fetuses living beings? At what point do they become living beings? But that's different than personhood, which is a legal concept, right? And also they introduced a balance, between state interest in protecting women's health and women's right to privacy. So they came up with this trimester system. So like during the first trimester, the woman had unconditional right to seek an abortion. Then in the second trimester, I think the state had to prove the lack of undue burden. I forget which legal standard they used, but the state could intervene, but not automatically. And then the third trimester, I think, was pretty much, abortion was more or less forbidden, right? So this trimester idea was replaced in 1992 in another case called Planned Parenthood v. Casey, where they went into the fetal viability, right? The notion, at what point is the fetus viable, I guess. So I guess if it was removed from the body, it could live on its own. I'm not actually sure what viability means, but that's the standard that they went with from there, right? So here's the doctrine that they relied on. It's something called substantive due process, which is basically, when you think of due process, you think of legal things, right? You're arrested, you're Mirandized, you kind of, you go through the loops, your rights are protected as you move through the system. But substantive due process is actually broader. It looks beyond procedural consideration. It looks like whether you are affected by some enactment of some policy by the majority, which infringes on your rights somewhat. A classic example is homeschooling. I think this is a case from like the 1920s. Some state or locality decided that all the kids must attend public school. And some parents sued saying, no, we want to homeschool our children. We don't want to send them to public school. And the court agreed. and they were allowed to homeschool their kids. Interesting thing, homeschooling is not a constitutional right, right? It's not in the Constitution. So the right essentially was synthesized as an unenumerated right, right? It was not there before, and now it's there here, you know. Then there's another doctrine called penumbra, where rights are sort of vaguely, you know, divine from other rights. It's kind of like reading tea leaves, you know, applying constitutional principles to infer rights. I mean, the easiest example is the Fourth Amendment against, you know, unreasonable search and seizure. You could say, okay, what they're really talking about is privacy. You have the right to privacy. You know, the state can just go in and like, you know, rummage through your stuff, right? So it's again, that's sort of broadening the initial language of what the amendment said. So the result is unenumerated fundamental rights, which the Ninth Amendment sort of refers to. Okay, so that's that. Thomas E. Dobbs v. Jackson Women's Health. So again, the beginning is synthetic. Mississippi passed something called the Gestational Age Act, for the sole purpose of it having, you know, having it bounce around in the Supreme Court. So it was again like the kind of like Roe v. Wade in a way, in reverse. So Jackson's Women's Health immediately sued in the U.S. District Court for the Southern District of Mississippi. They prevailed. They say the law is seen as serving no legitimate state interest, and the state is enjoined from actually enforcing it, right? So not only is it unconstitutional, the state might stop right away in enforcing it. That went to the Fifth Circuit. See, the Fifth Circuit is like the, you know, Hickville Circuit, right? It's Alabama, Louisiana, and Texas. So all the cool shit happens in the Fifth Circuit. So the Fifth Circuit looks at it, and it's a conservative circuit, and it rules 3-0 that the right to end pregnancy before viability. Even though they are conservatives, they nevertheless see Roe v. Wade as a precedent, and they say, no, you know, you can't do this, you know. And so it usually was heard by just a panel of 3 judges. The Court of Appeals is usually larger. So then Mississippi requested for I'm going to mispronounce this, en banc hearing, which means before the entire court, which the court rejects. So, okay, so nothing happens. So then Mississippi passes a heartbeat bill, right? When you can detect a heartbeat, you can no longer have an abortion. And Texas, I think, had a similar statute in 2019. Exactly the same thing happens. It goes before the district court, then the Fifth Circuit, they reject it on exactly the same grounds. So, so then the Mississippi Attorney General in 2018, Lynn Finch, appeals both of these Fifth Circuit decisions to the Supreme Court. Interesting fact, Lynn Finch was the first female Attorney General in the history of Mississippi. I wouldn't want her job. I mean, even if she is against abortion, that I just would not want to be there. But you know, such is life, right? So her argument, or the state's argument, I should say, that fetuses are actually fully human and may experience pain as early as at 10 to 12 weeks. And then additionally, she argues that the protection of human life is a state rather than a federal interest. So in other words, Roe v. Wade is really overstepping it because, you know, the federal government is making a decision and the state should really make. So this SCOTUS grants the petition for writ of certiorari, which means it agrees to hear the case. However, it sort of limits the scope of inquiry because there's like a question of jurisdiction, right? There's a question of undue burden. There were other questions, and the Supreme Court said, no, we're just going to look at one thing, you know, whether pre-viability prohibitions on abortions are unconstitutional. And SCOTUS indeed reversed the Fifth Circuit decisions by a 6-3 margin. Abortion is, you know, I think this was written by Alito, I think the main one, the Chief Justice, right? Abortion is not an unenumerated federal fundamental right because it is not deeply rooted in this nation's history and tradition, or it's not implicit in the concept of ordered liberty. Now, I don't know what to think about the second one. The first one, in my personal opinion, is blatantly idiotic because it says this is not a fundamental right because it used to not be a fundamental right. It's basically bootstrapping, you know, this is the way we always did it, therefore, you know, what do you want? You know, it was never part of this country's tradition, right? Which to me is a circular argument. So both Roe and Casey is the Casey v. Planned Parenthood case from '92, which sort of reaffirmed Roe v. Wade. Both are overturned by a 5-4 margin. Notice that the margin is different. Justice Roberts did not want to overturn it, and he reversed the Fifth Circuit decisions, but he did not want to overturn Roe. And in fact, he had these very elaborate contortions which is also, I mean, I don't have the time. It's like common law is fantastic. What he wanted to do with Roe, basically, he wanted to reinterpret Roe and say, you know what, Roe v. Wade really wasn't about viability. It was really about, women's right to have an abortion, basically. So viability, therefore, is not an issue. And so this is, what the plaintiff asserts really has nothing to do with the case, because Roe v. Wade is not about that, right? And the other justice said no, and probably correctly, And here is where you see this doctrine of stare decisis is disregarded, right? Because Roe v. Wade was one decision, and then they come over here and they change it, right? Which is very unusual. This decision is extremely consequential for American jurisprudence. It goes way beyond just depriving women of the right to make bodily choices. It actually upends just jurisprudence generally, which makes it in a sense more interesting in Roe v. Wade, which was more straightforward. The Warren Court always found more and more rights, and they used substantive due process to do it. Interracial marriage was allowed, contraception was allowed, right? And all of these things were, there's no right to contraception in the Constitution, right? So again, they used, substantive due process to sort of infer it. So what is the legal doctrine that they used? Originalism is the main one. It says, go back in time to moment of statutes enactment. So the 14th Amendment dates back to mid-19th century. It was passed after the Civil War. I mean, it's in the news recently, right? Article 3, Article 5, Trump, right? It's the same piece of legislation, except it's different articles. So at that point, abortion was already banned in several states. So it was already a thing, a policy thing. And yet the amendment does not enshrine it as a right or even address it in any way at all. So the argument goes, well, when they passed it, this was already an issue, and clearly they did not address it. So why are you, piling on these new meetings right now, right? That was one argument. The other part of originalism is that the meanings of words and phrases should be interpreted as they were used at the statute's adoption, which to me is like a linguistics problem, almost, trying to figure out what words meant. They do have a good example, namely domestic violence. So apparently in the Constitution somewhere, the federal government is required to come to the aid of individual states in the case of domestic violence. And I think even opponents of originalism would agree that what is meant is not that there are couples fighting and the president of the United States sends troops. It's about domestic rebellion, like the Shays Rebellion, or there may be the January 6th insurrection. I don't know if that will qualify. That's domestic violence in that meaning, right? Which is a very different meaning from today. And yet I think everybody would agree that they don't mean marital problems, right? So, and then there is, the sort of the legal doctrine of intentionalism, which is actually very typical. What was the legislative intent, right? What were they trying to achieve when they passed this legislation or this amendment, which is different from what does it say, right? It's trying to sort of get into the head of the founders, or I guess in this case it was, I don't know, Abe Lincoln, the Republican Party after during Reconstruction. But again, here, even Hamilton and Madison, who are the co-authors of the Constitution, they themselves could not agree what the thing meant in the first decade after it was ratified by the United States. So in the early days of the Republic, they had arguments about what it was that they just passed. So legislative intent is tricky. Next question I kind of came up with: do Black people enjoy Eighth Amendment protection against cruel and unusual punishment? Now, today you would say, of course, right? There's no difference. But at the time the Eighth Amendment was written, do you think Thomas Jefferson really thought that Black people, were protected from cruel and unusual punishment? I mean, he was a major slave owner. He was the biggest assholes out of all the founding fathers, who were all assholes, by the way. But he was the biggest one by far. Do you really think when they wrote it, says, "Oh, I'm thinking, yeah, of course, white people, Black people, everybody"? No. I mean, nobody would argue that that's what he thought. So therefore, maybe Black people can be, mistreated. And the coolest example is the 1964 Civil Rights Act. So initially it said you cannot discriminate on the basis of race. And then it was added that you cannot discriminate on the basis of race or sex. Now, this was added by the Dixiecrats and the conservatives because they wanted to sink the thing, because I guess, they either counted on members of Congress being misogynistic, which I'm sure many were, this was the 60s, right? Or they were just squeamish about sex. Right, so they kind of, sold it and said, okay, it won't pass. Well, it did pass. It became law. So now imagine a few years later, a woman sues and says, well, she's been discriminated at work, and the judge says, what was the legal intent here? Was it to protect the rights of women? No, not at all. The intent was to sink the bill. Right. So I mean, you come up with these totally idiotic interpretations, which defy logic. But yet, if that's what you want to do, well, that's where you're going. That's right. Okay, so this is my second to last slide. There's another doctrine that I came across called common law constitutionalism, where you begin with the original meaning, which is, I guess, what originalists would say, but then you accumulate case law and precedent over time. It kind of grows on top of the legislation, and so its meaning kind of drifts over time. One of the corollaries is that it has to be minimalist and moderate. In other words, it has to move slowly so that the legal system is predictable, right? It cannot make sudden left or right turns. And of course, stare decisis is a part of it. In fact, stare decisis is what makes common law systems work. So, if you get rid of it, I don't know what these Alito and company were thinking. And I mean, I just don't even understand how they expect this legal system to work moving forward, because stare decisis is actually important. Now, it is reasonable to criticize substantive due process. Again, it's something that was kind of invented out of whole cloth. The Ninth Amendment talks about unenumerated rights, but it doesn't really talk about, and this is how you do it, substantive due process, right? It doesn't say that. It just tells you that there are unenumerated or could be unenumerated individual rights. But in my personal opinion, without due process, substantive due process, the United States will become a failed state. And this is because the Constitution is a finite document. I think initially it was 4 pages long, the initial one. And imagine our country and the document that's 4 pages long that describes, how the country should function. I think with the amendments, of course, it got longer, but, it was a tiny document. And so the Constitution must adapt to all these changes, social, technological, political, and so on. Otherwise, the system becomes unworkable because you cannot reach any decision on any topic because, the world has moved forward. And therefore, I will repeat, Ruth Bader Ginsburg's claim, probably not only her claim, that the Constitution is, in fact, a living document. Scalia responded to it, said, no, it's a dead document. Scalia actually said that. It's a dead document. So, this is my second to last slide. My last slide I enjoy the most. So, as you know, Clarence Thomas actually has future plans for this. He looked at the other cases like Oberfeld, which legalized same-sex marriage, Lawrence v. Texas about sodomy, Griswold about contraceptions, and he says all of these are poorly decided because they're built on substantive due process, which he doesn't believe in. And he's not too crazy about stare decisis either. He's not believed it. So the ones in red or burgundy that I marked are the ones that he specifically mentioned, right? By the way, this is a nice picture. The top picture is him, I think when he worked at the Equal Employment Opportunity Commission. And this is Chris' coworker. Her name is Anita Hill. You might remember her. So then to me, really funny is Irving v. Virginia, which abolished miscegenation laws and now, which allowed interracial marriage. And I guess there's some question, would he support that as well? And in my opinion, he really would. He really would. And here's why. Here's his wife. This is Jeannie Thomas. As a gay man, I think I can criticize her dress. This is, if Thomas was a liberal, he would have gay friends that would teach her how to dress. I mean, this is just atrocious. But anyway, that's aside, However, I'm sure he's afraid of her. Men like that are usually afraid of their wives. So if he could repeal Loving v. Virginia, he would say, well, honey, we got to get a divorce. I mean, we're different races, right? We can make this work together. And that's my presentation.
Okay, Mike, you have to repeat all the questions from the inside of the room, okay?
Okay, I'll do my best.
We're gonna choose to speak. So anybody locally here wanna make any comment?
No, I have a question. Yeah. You made reference to something called ordered liberty, and could you expand on that? I've never heard
Yes, yes, it's a conservative notion, a conservative doctrine. Oh, yes. The gentleman asked about the concept of ordered liberty, because Scalia wrote it that this is not consistent with ordered liberty, Roe v. Wade, right? From what I understand, this is one of the conservative legal doctrines that states that individual rights have to be balanced against the rights of society and the stability of society. So it's kind of a, a balancing act, I guess. Of course, where you balance it, I'm sure depends on your ideology, but that's sort of the idea.
Okay. I take it you're monkeying Scott, is that right? Who focus on him? Can we have the whole thing back up again?
The slides, you mean?
Yeah, somebody's fooling around. Okay, anybody on the TV land there? Dana and Jerry.
Okay.
Now you have to turn the volume up on your computer because you're about.
Oh, you're not picking this up?
I can't because
Okay, hold on.
Dana and Jerry, you're muted.
you were gone. This is nuts. I don't know why it's not working this morning. It's not.
Okay, is this better? I mean, am I louder or?
Well, ask who's gonna.
Dana and Jerry.
Dana and Jerry,
But
yeah.
they're
just
muted.
Ask them to talk.
Okay, Dana and Jerry, give it a try.
You're
They
muted,
they
Dana.
need to unmute.
You have to unmute your speaker.
Okay.
I did. I unmuted. I know that. So
Okay, we can hear you. Okay.
okay, so I'm a little confused about something. I mean, most of my life I had the idea that basically old Supreme Court decisions could not be changed. You know, there was the idea that what the past decisions were kind of settled things, but apparently in this Dobbs case they didn't think that. So has there been an evolution of thinking about the value of precedents?
Should I repeat this question? I guess everybody heard, right? So stare decisis is a doctrine. In other words, it's just a way of doing things. It is not codified anywhere. And of course, like I mentioned before, I think any common law system that's not insane has to have it so that the law is stable and evolves gradually over time. Now, the current court, I guess decided that this doesn't matter, and I guess it wouldn't in a civil law system where everything is legislated, right? So in a civil law system, you go to the Supreme Court, there's a plaintiff and a defendant, and they play Rochambeau, and one wins, and that's it. There is no precedent being set, right? This is just the last, the final round of the March Madness, right? That's all it is. There's no nothing going further, but in common law there is. So this is very, very strange. There was another case, I think, back in the 90s. Apparently, the Supreme Court precedent held that access to guns should be held, should be allowed in the context of, you won't believe this, a well-regulated militia, which, that if your purpose was to, defend the state or defend yourself, you were allowed to bear arms. And I think it was Alito who just tossed it aside.
Scalia.
Or was it Scalia? Yeah, thank you. Because I guess, the right to bear arms, I guess he didn't realize that was a subordinate clause. That the first thing said, the freedom of a free state, right, being essential. Therefore, we need to bear arms. That was discarded, and now, the NRA says whatever the NRA says. Everybody can have arms, I guess. Again, it was a violation of stare decisis. I mean, a very abrupt drop off a cliff, right? So this is not the first time. I'm curious where this will go. Frankly, it's kind of scary.
What did you define stare decisis for those who don't know what it means?
Oh, it basically means, I think the Latin is like leave
Yeah.
alone or something like that. It means that you should, defer to precedent whenever you can, right? So even if you believe that a certain decision was flawed somehow, partially flawed, you should still say, this decision is okay. We would modify something like Planned Parenthood v. Casey. They modified the trimester rule, right? They replaced it with the fetal viability. So they did tinker with it, but they said, no, this is still the law of the land, right? And this is sort of how it would progress. Whereas here, they just pulled the plug on it. I mean, just all of a sudden. So,
Yeah. So how do they justify? I mean, as I said, it's like historically it seemed like, yeah, you could tinker with things, but you couldn't make any fundamental changes. But Dobbs was a fundamental change. So how do they justify that?
well, that's the thing. I don't think they have to. I mean, Thomas doesn't like substantive due process. He doesn't like stare decisis. And I think when Alito was alive, Thomas, I think he just voted with Alito. I don't think Thomas ever spoke in the Supreme Court before Alito died. Now he has to speak because Alito's dead. But it's a doctrine that you find a lot of stuff on the web about the rise of conservatism and religious fundamentalism and how you know they are affected in terms of, you know, I can understand how this colors their view on abortion, that, you know, there's a sanctity of life, you should not perform abortions. I understand it from that sort of moral standpoint. I personally disagree, but I understand it, I respect it. But what they're doing to the legal system itself, I find troubling. I mean, you know, unless we become a civil law state like France, you know, where you just have, you know, the Congress pass every law and decide everything. Maybe they should have all along, I don't know. So, yeah, they don't really have to. There's nothing that says you have to use stare decisis. It was just tradition. I mean, common law is tradition, right? It's promulgation of tradition.
Repeat the question. Alex got it in.
No, I was wondering the idea that a fetus is a person is expected to be strictly religious concept. I mean, how do you define it? It can't be DNA because there are identical twins, there are chimeras, or a combination of two fertilized eggs growing into a single individual. It doesn't have a brain. So it's purely
Well, I don't know.
probably religious.
I guess, I mean, what does viability mean? Does it mean that if, Alex was asking about, I guess, what viability means and,
No, I was asking what an individual means, a person.
well, what a person means.
Yeah.
Well, personally, I don't know. I mean, I have my opinion, but, it seems that, fetal viability, I think, refers to the fact that if, the woman were to have an abortion, then the fetus could survive on its own. Now, probably by its own, they mean in 1 million incubators. I don't think it would probably survive on its own, which is another, I mean, you know, what do you mean by that, right? Is it a living fetus, or is it just some, you know, I don't want to say tissue, but, you know, an organism that you're supporting artificially through medicine.
If you talk about IVF, that fertilized egg could survive if it's implanted in another woman.
Yeah. Well, Alabama's special, right? They're good people. Yeah, I mean, I guess this is part of the problem, that the definitions are kind of, you know, like the Mississippi Attorney General, right? That fetus can feel pain at 10 to 12 weeks. I don't understand the science either. How do they come up with this stuff? I mean, I'm not saying that they don't feel pain. I'm not a, you know, I'm not a doctor, but, you know, how does this enter into legal?
But I've got another question. Do you feel that the members of the Supreme Court have an actual vision of how they want American society to be?
I think they want to refashion it in very conservative terms.
Repeat the question.
Oh, what, I guess, what do Supremes want in terms of the future of American society?
Yeah.
I just think it's basically by hook and by crook changing, you know, the United States, maybe not to a theocratic state, but to a very conservative state. And you know, again, it's that in itself, I mean, I personally don't like, but I guess, you know, it's a question of philosophy, but they seem to be willing to just basically run roughshod over the entire legal system and legal precedent to get there, you know. I'm curious what will happen in the years ahead, you know. I was watching this video from Harvard Law School, and they said, yeah, this is huge. I mean, this is humongous, just because of the way it you know, disassembles the sort of the legal structure of this country, you know. So I don't know if I answered your question. I mean, I don't know this stuff.
Yeah, you say you don't know. So
Yeah.
Anybody else? Okay.
So looks like the cancellation of Roe v. Wade just got it out of the constitutional realm and left it up to the choice of the states.
Right.
If Congress later decides to allow abortions everywhere or disallow abortions everywhere, that will be the law of the land, right?
Let me repeat the question. So, you're saying the Dobbs decision basically returns the power to the states to decide, and then the second part was if Congress were to pass a law that allows or forbids abortion, that would be the law of the land. And I think if Congress, well, that's interesting. Theoretically, if Congress passed a law allowing abortion, I think that should settle it, because the at least according to current case law, because they didn't say abortion is illegal. They said abortion is not guaranteed. It's not protected by the federal constitution, and only that, right? So California, we have an amendment now. France has a abortion written into their constitution now. You know what backward people they are. You know.
Yeah, another thing, I was just projecting here. It appears that the Alabama decision says that an abortion is murder, which raises the question: if a woman has an early abortion in Alabama, is charged, moves to California, would Gavin Newsom have her extradited back to Alabama? And if not, that's kind of a mess.
So you're asking if
If you could hear what they're hearing out there.
so everybody heard it, I
Go
guess.
up to your computer.
You can't hear me now?
I can hear it.
Hear you, but if.
I can hear the room.
When he's talking, they hear you great.
Okay,
See what I
okay.
mean?
So the question was if a woman were to obtain an abortion in Alabama and then move to California, was that the
Yes, to avoid prosecution.
okay? That I don't know, but there's a situation of a woman from Alabama that moves to California and gets an abortion, and Brett Kavanaugh specifically addresses that and says yes, she can. So, you know, he respects that interstate travel, you know, because that gets into interstate travel, right? Are you allowed to leave the state? I mean, we're in the Soviet Union then, you know, if this is the you know, standard. So, but he explicitly actually carved out this provision. Now, I don't know if this carries weight as a matter of law. You know, they pulled out all the pucks. So I don't know what that means in terms of practical application, but he did make that specific caveat or exception. Yeah.
Jerry has a hand.
Go ahead.
Yeah, so you know, on the issue of the Supreme Court just wanting to do what it wants to do, and without regard to whatever prior precedents and so forth. In 2000, the Supreme Court ruled in to stop the recount that was going on in Florida, and basically then declared that Bush was the winner. And then a prosecutor in Southern California wrote an article in Nation magazine about it, saying that the Supreme Court was dead wrong on that for a variety of reasons. It was just, it was almost like it was criminal. And that got a lot of letters. Apparently more, the Nation magazine got more letters to the editor on that subject than anything else in its 100+ year history. And later he wrote a book about betrayal of America, which really is a scathing indictment of the Supreme Court. And you know, nowadays it's like, I don't know about the whole history of opinion of country's opinion of the Supreme Court, but I do know that right now it's very low. And we got a real problem now because low opinion of the Supreme Court, low opinion of Congress, low opinion of the executive branch, you know, and low opinion of the next whoever might become president. You know, the U.S. is kind of at a really low point, and I'm done.
Yeah, no, that's it's confirmed that the Supreme Court's ratings or, you know, acceptance by the public just nosedived after this decision. Support for abortion rights increased, as you probably know. A lot of the red states, I think Kansas, have passed either constitutional amendments or laws protecting the right to abortion. So this is not just blue states, right? So this really hit a nerve, and you know, I'm not James Carville, but I think the Dems could really play this well in the elections if they so chose. But Bush v. Gore. Apparently, we do not have the right to vote in the presidential elections. I think that was part of the decision because the founding fathers are not betting on elections. They allowed us to vote for the House of Representatives, and that's it, not the Senate. The president was elected by the Electoral College, right? They didn't want riffraff picking a president. I mean, come on, right? So I think that was actually part of the argumentation that some of the votes that were being counted in Florida, actually, that it's not actually strictly necessary because there is no inherent, I could be wrong. Please let's look that up. That's what I read. That there is actually no inherent constitutional rights there. Have your vote? I mean, this is just freaky, but that's what I read.
No, I think you're probably right. You didn't point out about the Senate. It used to be that the senators got elected by the state legislators.
Or appointed, right? I think every state had a different approach, right?
Oh, could be. I don't know.
Yeah.
Ridiculous and it's not a can.
Okay, well, Carl, why don't you be the MC and just,
I can't.
oh, Dick, go ahead.
Yeah, Zem, you brought up something that I think is really important, and that is that I think the overturning of Roe v. Wade had a wonderful consequence because almost every state has now made abortion legal.
Really?
Well, some did, right? But not,
Well, you made the comment, yeah, including red states.
yes,
I don't know how many, but
yeah.
you know, that I can't answer. But I know many states have now made abortion legal as a result of the overturning of Roe v. Wade.
Yeah.
Also, I think that in the red states, it was not decided by the state legislature. I think it was done by citizen referendums.
I think so. It was like propositions, like we have.
Yes.
Yeah.
I think so, yeah.
Another example of the people disagreeing with their alleged representatives.
Are you muted?
He's done now.
Oh,
Somebody had one here.
oh, Alex.
Yeah, I like the comment you made in your written introduction that kind of like talking to you. That the legislature is pretty much paralyzed, and that's put a lot of power in the hands of the Supreme Court.
Mhm.
And the trouble is that most American people think religion is a good thing. And it became a necessary quality for the Supreme Court justice. As a result, they're not typical at all. They don't think like most Americans do, and they've got their own agenda.
Mhm. Did you guys hear it or?
I think you should repeat at least just.
Yeah, so Alex said that since this is being left to the courts because the legislature is dysfunctional, we can then, people can push religion by claiming that this is, really part of our fabric, even though it's not, and then most people would disagree. Right? Or am I?
That's what I'm saying.
Yeah.
Most people think religion is good, and that's as far as it goes.
Yeah. Yeah, I wonder how many fundamentalists there are, really. I don't know. Well, Catholics also love their laws. I mean, Catholics were the big opponent of Roe, as you may imagine.
But
Probably more than Protestants, actually.
But a large percentage of the people who did clinic defense at Planned Parenthood were Catholic.
Well, actually, the issue about Catholics and abortion, I understand that, and I don't know about now, but at some point in Europe, Spain and Italy had the lowest fertility rates in Europe, even though they're largely Catholic countries. So, is this really true that Catholics are opposed to abortion, or is it just the church that's opposed to the abortions?
I would guess that Italians and Spaniards, is it?
Yeah.
Just don't reproduce. I don't think it's a question of abortion. I think the question of per capita GDP. Wealthy countries do not reproduce because they have electricity and internet and televisions. Rural India, they reproduce because they're just nothing. There's a water well, So it is about GDP. There's an inverse relationship between religion and GDP and population growth and GDP, so I don't think they abort a lot of, I could be wrong. But that's not my impression that they're like having abortions left and right.
Most Catholics don't support it in the United States and also in England. So when they vote, that's the way they vote. We people understand.
That you said most Catholics do not support abortion in the United States? Okay.
Just the Pope and his ilk. They're like the constant, they're like this.
I mean, that you're not opposed abortion.
Yeah, they do. No, they oppose abortion, yeah. Officially, they oppose it.
Well, officially, yes, but
Most Catholics that I have ever met don't. They say people should be left alone.
Yeah.
To do what they want. Most people say.
yeah, I don't know about Catholics. I did read somewhere that in the old Confederacy, for lack of a better term, abortion rates are actually higher because there is limited access to contraception, like in schools. And so, you kind of kick the can down the road and then, you're faced with a societal problem, right? So But it's something, I read somewhere. I kind of sound like Trump right now. I heard something somewhere. Oded, go ahead.
Tony's muted.
You're muted.
Are you talking to me?
No, to Oded.
Oh,
Okay. I have a question. What about the right of the man in the unborn baby? Does it have any right also? Or it's completely neglected? Thank you.
It's a good question.
Yeah, so the question was, what rights do men have in this equation, right?
Yep.
I mean, you mean fathers, right? You mean fathers of the
Right.
Yeah.
I don't know.
So nobody talk about that. We try to throw it under the carpet. Or it's really
What
important.
the jurisprudence says on this at all.
There have been cases where a couple went for in vitro fertilization, had fertilization, and then they split up. And the husband, the ex-husband, sued because he didn't want her to have his children. And I believe he lost the case.
There've also been cases where the man has sued to prevent an abortion and the court has ruled in favor of the woman's right.
You're never getting back to repeat what she said.
So the lady said that there was a case where a man sued, I guess his wife or girlfriend, into not having it, to try to her to stop an abortion, and the court ruled in her favor, right?
A bunch of men arguing about women's
You're welcome to
bodies.
say something. You
I
want to
don't
say,
want to say anything
why not?
because I every
Because you don't.
because
Okay, we're gonna have to mute you guys, don't shut it
it's
up.
ridiculous anyway
Dana and Jerry, something.
But- for women what they need. I'm sorry, I just
I
beyond.
think Oded has a good point, though.
Dana and Jerry, maybe you should mute yourself. Self.
may I talk?
Yeah.
Yeah, well, go ahead, Dick.
Well, I know that in the United States, in spite of the church's teaching, most Catholics practice birth control and have abortions. And I would assume that that's probably true in Spain and Italy and everywhere else. That's what I wanted to say. Well, I have a question. What is that thing behind you?
It's a bullhorn or megaphone with a cork in it.
Oh, okay. Thank you for explaining.
Who?
Greg,
Greg, go ahead.
Yeah, I just wanted to note that I've added to the chat a number of web pages on the topics that have been raised. And there are web pages in Wikipedia on paternal rights and abortion and religions and abortion, which have been discussed, but without in the form of mostly questions. And you might look there for some of the answers.
Actually, maybe I'll ask Oded. I understand that there are some, maybe not exclusively Oded, that there are some Jewish denominations that actually proactively believe in the right to abortion. And when DeSantis, when Florida signed some of these laws, or maybe it was a city that tried to ban something, they sued, saying, no, it's our religious right to have this. So this kind of turned everything on its side. So I don't know where that went, though.
they also have questions here.
So there seems to be an inherent hypocrisy in the red states, protecting the sanctity of life, but yet wanting to make an exception for in vitro fertilization. So if embryos are living beings, they should be protected, and yet they want to have in vitro fertilization and dispose of embryos and so on.
So did you guys hear?
Just repeat.
Yeah, that's, the red states are hypocritical because they're against abortion, but they actually want to protect in vitro fertilization. So there's an inconsistency. I can tell you my theory of why the Alabama legislature moved so quickly, because Trump said he likes IVF. if Trump said he doesn't like IVF, I mean, the Republican Party is a cult right now. It's not a functioning political party, in my opinion. So he could say, he doesn't like it tomorrow, and maybe they'll repeal it, or I don't think there's any rhyme or reason to it. You're looking for like intellectual consistency between the. Yeah, I mean, it's just my opinion, but I
just, I looked up on my phone the map of the states that are supporting abortion.
Mhm.
I sent you an email with a link. I mean, you don't have to look it up, but if you wanted to show it. Just go to that.
Yeah, you can't do that.
You can't do that.
I mean, I don't know what it did with the email. I'm sorry. I mean, maybe I could, but
No, you don't have to.
yeah.
I don't know how to get it to, let's see, who's putting all the links up.
Oh, Greg. Okay.
That's, I don't know. Without signing in.
Right.
Remember, they can't hear her side of the conversation, so.
I'll send you.
You said she found a website.
Yes, she found a website, a graphic illustrating which states have pro-abortion or pro-choice, I guess, amendments or registration or some such.
Send it to Greg.
Okay.
You can say that.
Anybody else? I want you to ask if anybody would have, any more comments.
Any more comments, questions, threats?
Dana, Ms. Jerry.
Oh, Dana and Jerry, go ahead.
Yeah, one of the problems that's arisen from all this is that some of these abortion laws are so restrictive that you have a situation where women can't have an abortion, even in the situation where allowing it to continue means that the mother and child will die. Well, that's totally absurd, and I don't know how they justify that.
Yeah, so Jerry said that these abortion restrictions are absurd to the point where the life of the mother or the health of the mother cannot actually be protected. I read an article where there's I forget if it was in the context of IVF or abortion. There was some sort of a disease that leads to I guess a reduction of white blood cells. There is a condition which calls for determination of the pregnancy. This condition can be predicted. In other words, there's like a curve of some metric, I don't know what it is, but they can't touch the woman until it reaches the point where she actually gets sick. So even though they know what's going to happen, they're not allowed to intervene. Then there is my old country from which I immigrated, where several women have died because Poland has very strict anti-abortion laws. I mean, they're really nuts too, and so and in a bad way, because the doctors actually waited for a stillbirth. They didn't want to intervene because they didn't know if they would be prosecuted for it. Let me say something about the IVF legislation. I was actually reading Andrew Sullivan. He's my favorite, go-to person. The IVF legislation in Alabama actually goes too far. Because, initially the idea was, okay, the IVF clinics, if they perform this, they can be sued, right? They're liable. But the law says not only can they not be sued for performing IVF, they also cannot be sued for malpractice, which is, goes in the other direction. So, if somebody screws up, if the lab loses the embryos or something, they seem to be indemnified under Alabama law. So they were really quick, I mean, Trump must have really gotten to them. It was not a good piece of legislation, so. Okay, go ahead, Will.
Yeah, I just have a comment, and it's just something I want to put out there, and it's not really something necessarily I wholeheartedly have a lot of experience with, but there's a premise about how the issue of abortion became such a political wedge issue in the United States, and it tracks back to religious universities wanting to maintain segregation while still having tax exempt status in the 70s. So Bob Jones University, for example, they couldn't campaign on the issue of segregation, but they decided on the issue of abortion because it was more politically palatable to their constituents. And so the premise goes that the whole issue of abortion from a religious stance is really just a cover for religious universities wanting to maintain their stance on segregation while still getting tax exempt status. It's not really. It sounds a little conspiratorial, but there's a lot of literature out there to support that premise, and so I just wanted to kind of put that out there. Yeah.
It sounds plausible. I mean, wedge issues, like in 2004, right?
I can put up a Politico article about it if anybody wants to read it.
Yeah.
Yeah.
No, wedge issues are real. Like in 2004, the Republicans were not really that excited about G.W. Bush. He was not sort of a candidate that drew people, but the Republicans really, really hated gay people. So what they did, and they had all these propositions banning gay marriage all across America. And that drew the Republicans out. And since they already showed up at the polling booth, well, they pulled the lever for Bush since, they're already there. I think the Dems could do the same with abortion this time around, if they're smart, but they're not smart. But, but I agree with you. Yeah, it's an interesting way of, so you're saying they would protect their nonprofit status because
what I'm saying basically is that the whole issue of abortion from a political standpoint, from a political standpoint, as far as a political tool for the religious right, it's really just a cover for them to be able to maintain, for them to fight for tax exempt status for their religious institutions in terms of them being able to continue to maintain certain unpopular ideas like segregation, like and other things of like more so racially charged things that they want to continue to practice, but they can't campaign on that. So they chose abortion as the issue that they can campaign on to advocate for their quote unquote religious freedom, essentially. Sorry for the word salad. It's a little
no. It's very interesting. I thought churches cannot campaign though.
What's that?
Right.
Would you say
That churches theoretically are not allowed to endorse candidates, right?
Well, I mean, come on.
The community in Silicon Valley, we are a church according to IRS rules, so we can't, campaign for anybody, endorse anybody.
And super PACs never coordinate with their candidates.
Oh,
so of course not. Of course.
ESP, So no, this is interesting. This is interesting.
Yeah, I put up a link to it if anybody's interested in it. It's just a thought. But it's interesting.
Mm-hmm. Yeah, why did it blow up?
Yeah, because when Roe versus Wade passed, there originally wasn't that much. There wasn't a strong movement against it, even from the evangelicals.
That's
but
true.
It became that way in the 80s.
Yeah.
Right. So why? Right. And that article proposes a theory for it.
That's probably why the ERA also, eventually got killed, right? Because initially many states actually ratified it very quickly. Then some states actually rescinded it, like North Dakota, I think, ratified it, and they said, oh, no, because, the wind was blowing to the right all of a sudden, and so, hands off, right? And in 2020, I guess theoretically could have become an amendment, like the congressional pay.
I want to mention that though churches cannot endorse candidates, if FFRF reports them to IRS ignores them.
Yeah, what good is a rule when nobody enforces it?
That's right.
So any more or Dana and Jerry?
Yeah, I saw an article once about this issue about the ERA and the various aspects, including the fact that I think there were 2 states that actually rescinded it and the deadline. And that article made an argument that essentially people could argue that the ERA has passed and is now the law of the land if they just push it a little bit. I don't know how true that is, but it was a plausible argument.
Yeah, there is some sort of a Democratic caucus devoted to this. I forget what the exact name is. There is like a political subset of Democrats that actually, make the exact case you're making, that it's, I guess these limits or deadlines, they're not really based on the Constitution or anything else, right? It doesn't say in there you have to do it in a certain amount of time. So it's interesting, right? How that will play out.
I think there were some amendments where there were no deadlines. As you said, there was something that was initiated in 1789 and got passed recently.
Right. I don't know if any other amendments were deadlined. I'm not a constitutional scholar.